Hello, this is the This podcast from Nolan Hyman. It's a podcast about emerging technologies. And in this episode, we're going to talk about some intellectual property myths. My name is Adam Diament. I'm a patent attorney at Nolan Hyman. And there are different types of patent attorneys, and what I focus on is called patent prosecution. And what a lot of people hear the word prosecution, they think about criminal prosecution. That has something to do with fighting patents in court. But that's not what patent prosecution is. Patent prosecution is the writing and getting a patent granted by the United States Patent and Trademark Office and other trademark offices and patent offices throughout the world. So if you're fighting about patents in court because you think someone infringed your patent, that's called litigation, but I focus on the prosecution part. And what involves is me talking to inventors about their invention, searching patent databases to see if there's something already out there similar to your patent, and writing up the invention in a way to get the broadest amount of protection for the inventor. And this applies to, could be complicated things such as artificial intelligence, machine learning, also simple things such as a dog collar. On the podcast with me, I have another partner at the firm, Ted Nguyen. Ted, you want to introduce yourself?
Yeah, thanks so much for having me here today, Adam. I have none of those things that you just mentioned. I actually know very little about patents, but I specialize in entertainment law, which is kind of a broad statement, but I primarily focus my practice on the emerging medias, social media, influencers, digital content creators. And yeah, I've been doing this now for like 7 years. So thanks for having me on here today to talk about patents.
All right. And just to reiterate, Ted is not a patent attorney. And actually, patent law is not something that's covered in the required classes in law school. It's not on the bar exam. So unless you specifically take a class in intellectual property, you're probably not going to know anything about patent law. It's actually the only area of law where you have to pass a separate bar examination to do it. So if you just go to your regular attorney and say, hey, can you do this patent stuff for me? They wouldn't even be allowed to do it. So I'm going to be posing some questions to Ted, not expecting him to get most of these right. That's typical of attorneys that aren't patent attorneys, but it's also probably typical of many of our listeners who don't know much about patent law as well.
I really appreciate that disclaimer.
All right.
So that everyone knows what to expect.
Exactly. So I remember before I went to law school and, I'd ask an attorney a question, whatever it was, I'd always say, it depends. And I always hated that. I was just give me a straight answer, like yes or no. And then when I became an attorney myself, people would ask me a question and then I turned into the attorney I didn't want to be. I kept saying, it depends. So when I ask you these questions, some are going to be true, some are going to be false, and some are going to be, it depends, but they're not all going to be, it depends, because I hate that as an answer to everything.
Okay, well, bring it on.
All right.
I'll try not to fail.
Okay, before we go into specific myths, maybe some of our listeners don't even know what a patent is. So here's your first question. True, false, or it depends? A patent gives you the right to make and use your invention.
Oh, this is one of those subtle law school questions that are like, it's like so obvious that it's kind of tricky. It's like when my civil procedure professor asked me what a claim was, and I had really no idea how to answer that question. But does it give you the right to use your invention? I'm going to guess and say no. Like, it's just not, it's never like an automatic thing.
All right. So what would you say? Do you have a guess on what you would say a patent is or what it does?
I think it just
give you the right.
A patent gives you the exclusive right to use the patent, but it doesn't necessarily mean that you have the right to it. I don't know. That sounds really kind of like a roundabout way of trying to say something very simple. And I'm sure you have an easier way of saying it, but I don't even know if I'm correct in saying no to that.
You're getting a little bit closer. And actually, the answer is just false. It doesn't give you the right to do anything with your invention. What a patent gives you the right is to stop other people from making, using, selling, or importing your invention. So maybe you think it's a nitpicky point, stopping people from making and using and selling isn't that the same thing that I'm allowed to do all these things with my invention. But you can think of lots of cases where you have a patent and you actually can't do anything with it. So one example would be, let's say you come up with a patent for a new drug. All right, you have the right, you have the patent. If you don't have FDA approval, you can't sell it, you can't make it, you can't use it. So all you can do is stop other people from doing it, but you can't do it yourself without other permission. Let's say, in a more extreme example, you came up with a new invention for a new kind of atomic bomb. All right. doesn't mean you could use it. It means you can stop other people. And maybe kind of the example that kind of comes up the most is, let's say that let's say it was a long time ago. No one had come up with a pencil yet. And you figured out, I'm going to have this piece of wood. I'm going to put graphite in the middle of it. And you end up getting a patent on it. Someone else comes along and they say, it'd be really cool on this. Let's put an eraser on the end of it. And, you get a patent with that pencil and eraser. So you think, okay, I could just make that, pencil and eraser. Would you be allowed to make your pencil and eraser, Ted? That's kind of your next question.
Would I be allowed to make my pencil? I guess
if someone else has the patent on the pencil, but you come up with a new invention or you add an eraser to it and you get a patent on that pencil and eraser combination, could you make your pencil eraser combination?
No, because if you're building off of the original patent, correct? Is this the scenario?
Right. Yeah.
So no, you can't build off of, you can't use what is on that patent application to build off and create something better until the rights to that patent have expired.
Right. So there are a couple of ways we can do this. So if someone has a patent on the pencil and you're doing everything that the pencil has that's in the patent, you add something to it, you're still making that patented pencil and you're adding something to it. So if you actually want to make your pencil eraser combination, you'd have to get some kind of license from the original pencil holder, or you could say, hey, I would like to buy your pencil patent from you. So that's generally how it works. So you could see, I get this question a lot from clients is, well, I got a patent on it. Why can't I still do it? Well, if your patent is building on other patented things, you still have to be aware of that and you still might not be able to do it.
Right. That's like the whole point of why a patent expires like in 25 years, right? It's so that people can build off of it. That's the whole reason.
Exactly. And that actually leads us to our next question. And this question actually appeared on Who Wants to Be a Millionaire? I looked at the date because I remember when it happened. So I looked it up. I got
what was the value of the question?
It was $500,000.
Oh, so it's going to be hard.
It depends who you are. It was easy for me, but not for the contestant. The contestant did use their 50-50 and they did get it right. It was May 2nd, 2000, if you ever want to look it up. So this is going to be the question. It says, for what period does a utility patent give an inventor the sole right to manufacture an invention? And the choices are A, 20 years, B, 14 years, C, 50 years, D, forever.
I think I actually know this one, and it's sad for me to think that I could have won $500,000 had that have been me, but it's 20 years, right?
20 years. That is correct.
I thought it was 25.
Yeah, I was going to say, I didn't want to correct you at the time because I wanted to see what you'd say for the question. So 20 years. That's a general rule. There are some exceptions, especially if the patent office takes a long time to review your patent. It's not your fault. They'll tack on sometimes or some other exceptions too. But in general, 20 years protection. And that means that you're allowed to stop other people from making, using, and selling your invention. After those 20 years are up, it's considered the public domain. Anyone is free to copy it. Now, the question did say utility patent. And, just so our listeners know, there are different kinds of patents. But a utility patent is what most people think of when they hear a patent, that it has some kind of use or it does something. The other two kind of patents are design patents that protect the look, and there are plant patents that protect certain kind of plants. But most of the time when people just say a patent, what they're talking about is a utility patent. Now, maybe you didn't catch this, but I'm going to ask the question again, the same question, and there's actually something wrong with the question itself. And some patent attorneys online actually said, this question isn't really a good question. So I'm going to say it again and tell me what we talked about so far, if you can figure out what's wrong with it. It says, for what period does utility patent give an inventor the sole right to manufacture an invention?
Can you repeat that one more time for me?
Yes. For what period does a utility patent give an inventor the sole right to manufacture an invention?
Well, the issue is the manufacturing part. It doesn't give you the sole right to manufacture something.
Yeah, exactly. So what we talked about before is that it gives you the right to stop other people from doing it.
Right.
It doesn't give you the right to manufacture. Maybe there are lots of reasons you can't manufacture it. Maybe it's like, I don't know, poisonous or whatever it is. If there was another choice up there that said none of the above, technically that probably would have been a more correct answer. So if Who Wants to Be a Millionaire, if you ever need an attorney to read over your legal questions for accuracy, I'm here to help out.
To your help.
All right. So now that we know what a patent is, let's go into some myths, or maybe they're not myths, or maybe it depends. And let's see if Ted can get it right. A patent will protect my invention worldwide. True, false, or it depends?
I want to say it's false because patents are just filed here with the USPTO, and the name in and of itself should reveal that it's just the US, right? And you probably have to seek other type of registrations in order to get your patent protected in other places.
Ding, ding, ding. You got it right. The answer is false. So the general rule is that there is one patent per country. So a US patent is only good in the United States. A Canadian patent is only good in Canada. Now, there are some exceptions to this one patent per country rule, but they don't apply in the United States. Some parts of the world have regional patents. So there's a European patent that covers more than 30 countries. There are several countries that got together in Africa, a Eurasian patent. But in general, it's one patent for one country. And if you have a US patent and only a US patent, anyone can make and use your invention anywhere else in the world besides the United States. But remember that you do have the right to stop others from importing your invention in the United States. So sometimes a client will tell me they have a US patent. Can someone knock it off in China? And the answer in this case is yes and no. People would be allowed to manufacture a knockoff invention in China, a knockoff of your invention in China. They can sell it in China. They can export it anywhere out throughout the world except the United States, because if you have a patent in the United States, you can stop those importations of the Chinese knockoff into the US, because the US patent does protect that, but it doesn't protect what happens outside of the United States.
I have a follow-up question to that then. If you have a patent, I can't really think of the example, but if it's for something that exists online, how do you protect that? Like if it's to like a process to like a code or like a processing system that occurs on a computer on the internet, for instance, and you have the patent here in the United States, but then someone over in a different country uses that technology and distributes it online, like how would you protect yourself in that scenario?
Yeah, I think that would be pretty difficult to do, which is why a lot of people focus on getting patents in a few key, industrial places. Like if someone comes to me and, they say they want a worldwide patent, I say, well, if you're willing to spend millions of dollars, we could get a patent in every country. But a lot of people focus on, let's do China, Japan, Korea, Europe, because once it's out there, if someone is distributing that information and they're in the United States, you could probably get those servers to remove that information, but it's probably difficult to stop someone, especially if it's a method patent, a method of doing something. If you're just telling someone to do it, technically that's called indirect patent infringement, because they're not doing it themselves, but they're telling people how to do it. But in another sense, the patent itself is a description of what to do. So anyone could look up the patent and see a method. And the question is, are you actually performing this method, or are you directing people, say, hey, everyone, you should do this because the patent actually tells you, how to do it? Then that could, that also would be patent infringement.
So you said which countries is like a good starting point? Yeah,
I would say oftentimes, people like to get China just because a lot of stuff happens there, manufacturing. They have been getting better in IP, because I've heard clients complain, say, oh, I hear it's so bad in China that everyone just knocks off everything. I've heard it is better than it used to be. Europe, because it covers so many countries, there's that European patent I mentioned that combines over 30 countries. And oftentimes it'll be Japan, South Korea, Australia, Canada. Those are kind of the big ones that people get.
Got it. And it's pretty expensive, I'm assuming, just in filing fees to do it in those countries.
There's a high cost of getting a patent. I tell people, words you'll never hear from a patent attorney are, this won't be expensive at all. To get something on file initially, it may be somewhat of a low cost. It could be, when I say somewhat, it's relatively speaking in the patent world, to get something on file, let's say in the United States, it might be $10,000. But then if you're using that same application throughout the world, you don't have to rewrite it every time. So it won't be as expensive. Maybe it's a few $1,000s to file. But by the time it gets examined and you're hiring attorneys in those countries and you pay yearly fees for them, I tell people, unless you're willing to spend, minimum 15 to 25,000, it's probably not worth it. That's money you could be spending on, marketing or business development or other aspects. So here's your next question, Ted. We've talked about how there's no international protection with the U.S. patent, but is there an international patent application? True, false, or it depends?
In my heart, I would love to believe that there's like a UN of patents out there in the world, and maybe even like WIPO. Is it WIPO? Am I pronouncing it right?
Yeah, there is something called WIPO.
Is with I don't know if they would do patents. I know they do trademarks, but I'm going to take a guess and say that they also handle patents. Why stop there?
Yeah, so it is true. So there is we mentioned WIPO. It's an acronym for World Intellectual Property Organization. So even though I said there's no worldwide patent, there is an international patent application. That sounds kind of weird because, how does that work? So how can you have an international application if there's no international patent? And the way this works is that there are currently 157 countries throughout the world. They got together and they signed something called the Patent Cooperation Treaty, and it's through WIPO. You'll hear it called the PCT, the acronym for it. So you might hear International Patent Application or PCT application. It's the same thing. And it doesn't turn into a patent by itself, but what it does is it serves as the basis for your application that you then file in foreign countries later. So let me give you an example. Let's say you're an inventor, you want protection in the United States, China, Japan, Europe, Australia, Singapore. There's no patent that covers all of these places. But if you had an idea and without this treaty, you'd have to file separate applications in all these countries, all pretty much close to the same time, get translations, find attorneys, pay all these government fees and attorneys' fees all at the same time, and it can get really expensive. So what the international application does is you file one application in an international office, and then that serves as the basis for all of these countries. So you don't need to file everywhere all at once. File that one application, and what happens is you generally have 2.5 years from that date to then pick what countries you want to go into. So a lot of people will use this strategy to kind of delay costs, because let's say you have an idea, you don't know if it's going to make a lot of money. You don't want to be spending, $50,000 plus, right away. But then you file an international application, you have some time to think about it. And then at that time, then you can say, okay, is it worth it to now go into all these other countries? And when you go into these other countries, they all are working off of essentially that base application. So for many people, I kind of give a rule of thumb, if you're interested in more than 3 countries, then it's probably worth considering doing this international application.
What do you mean when you say it forms the basis of the application for the other countries?
So we file this application, and in a patent application, you describe what your invention is, you describe the boundaries of it, and it's uploaded to a server that kind of keeps this application. And then what I do is I have attorneys in countries throughout the world, and I say, hey, we have an application. This is the application, the international application number. Take this and submit it to your own patent office in Japan or whatever. So we don't need to rewrite the application. Depending on the country, you might need a translation of it. But the advantage is when you go into those foreign countries, it's as if you had filed it on that earlier date. And that's one of the main reasons people do it, is because if your invention is out in the public for too long, it's considered part of the public domain. So if you have an international application on file, it's as if you'd had filed it throughout the world on that early international filing date. All right, let's do the next myth. And maybe it's not a myth. Maybe it is. Let's see what Ted thinks. An inventor owns all of the intellectual property they create. True, false, or it depends?
This is giving it depends, because it just really depends on what the inventor invented. And I think that's a very subtle thing.
What do you mean by what the inventor invented?
Repeat the myth again for me.
Okay. Inventor owns all of the intellectual property they create.
Okay. So this kind of goes back to what we were just talking about. If they're building off of another patent, I'm assuming, will likely have to disclaim the parts of it that have already existed.
Okay.
And that they're building off of, and they can only claim the things that they've added on to that invention.
Okay. So let's say they're only claiming that part that they came up with themselves. Do they necessarily own it themselves? Own that new part?
The new part. Yeah. They would own it for the amount of time that a patent allows them to own it for.
All right. So I'm going to go with incorrect for that one. That's okay. But the answer still is it depends. That's probably the most correct answer. And I'll go into kind of the scenarios where maybe the inventor wouldn't own it. So by default, the inventor of the invention owns that intellectual property. So let me give you one scenario. Let's say you're unemployed, you're at home, you come up with an invention, you file a patent application, you're listed as the inventor and the applicant, you get a patent. That's easy scenario. You are the owner of that patent. If that's your case, you have the sole right to stop others from making, using, and selling your invention. Now, the biggest issue of where it depends comes in is if you're an employee of someone, where maybe you don't own your invention, but the employer does, even if the employer didn't invent anything. So here's another scenario for you to think about, Ted. Let's say you're a computer scientist and you've come up with some new AI for when you write in a text prompt, the pictures, the images that come up, they are going to be much more realistic. And who do you think would own the patent rights to that new kind of software, new coding that you've come up with?
So, and this is a person that works for a company, you're saying?
Yeah, let's say they work for Google and they come up with this.
I mean, I would ask to see the contract, to see what this person signed. And if it has that magic word, those words that you don't want to hear sometimes, if it's a work for hire, it means that your company owns it.
Yeah, so I thought I was in a tricky one there because remember the default position is that the inventor owns the invention. All right. So the question is whether this strays from that default. And most of the time, if we're talking about employee situations, there is something in that employee-employer contract. You probably didn't even look at it when you joined the company. There's probably some clause there that says, all inventions are assigned to the company. So for most situations, if you've come up with something and you're working at a company, most likely it's going to be owned by that company. So let me give you kind of another scenario. Let's say you're that same computer scientist, you're working at Google, you signed something that said, you assign all inventions to the company, but you come up with a dog leash, all right? Who in this situation here, who do you think would own that dog leash patent if you were able to get a patent on it?
Well, if your position at Google is dog leash maker, then if it would be within like the course of your work at Google. And if that's the case, then Google would likely own the leash as well. In a weird world where you're like an inventor at Google and making dog leashes for them, then they would own the leash. But if it's truly has nothing to do with your job at Google, then I would say you would own the dog leash.
Yeah, that's probably how it would work. So even though if your contract says, all inventions, are going to be owned by the company, courts generally don't interpret it that literally. And it does depend on what state you're in. So California is very inventor friendly. And they'll look at different factors. One of them is, how related is it to the work that you're doing at the company? If it's totally unrelated, like the company wants you to do AI work and you invented a dog, leash, that's a factor that kind of weighs for the inventor owning the patent. But let's say he was doing all of this, dog leash invention at work time, using Google computers, doing all that kind of stuff at Google. Google's going to make the case like, hey, he was our employee. He was on work time, even though we don't do dog leashes, this is still, our invention. So that's the argument they would make. If the guy was only doing this on weekends at home, not related to his work stuff, then all that stuff kind of leans in favor of the inventor owning the invention. But there's going to be lots of gray zones. And that's why we have patent attorneys to fight about, all these things about which factor is more important.
Yeah. And I think for most of these employer contracts, there is a disclaimer that you can make for prior inventions, that things that you did before working at the company, that you're pretty much claiming, hey, you don't own any of this stuff. It was in existence prior.
Yeah. And even if that wasn't there, they probably would own it anyways, because as I said, by default, the owner owns the invention unless there's something specific that says otherwise.
So what happens if you incorporate things that you had quote unquote invented prior to working at Google, for example, and you incorporate all these things into the Google work that you've done?
Yeah, I mean, I could see, that's a type of case that probably comes up a lot where there's a mix of knowledge that goes in. And, probably what it comes down to is in the kind of finished product of the patent, if there are aspects of it that you have come up with that while you were an employee, I think Google probably would have, or whatever company it is, would have pretty strong legal arguments to say that the invention is theirs.
And money.
Right? Yeah. And so I've seen inventors kind of have in that contract, when they sign up with a company that specifically says, I have done this in the past. I want to keep, this and any modifications I do to it as part of my own. So that has been part of the negotiations that I've seen, happen. I think probably some of these big companies are probably just saying, hey, we're not signing, anything that where you can retain your rights. But, if you feel like you're in a strong position as an employee and they're trying to recruit you, that's something that you could negotiate.
Okay. So Adam, I actually have a question for you for maybe some of my content creator clients out there. So if you are like, for instance, a makeup artist and you have a very specific way of applying makeup and you apply for the patent, I'm not sure if that would be granted. You'd have to tell me. But let's say, for example, that this person does have a patent and they're doing it online and showing people how to do it. And other makeup content creators then try your process. Does that original owner of that makeup process now have the ability to charge people for doing it online?
Yeah, potentially they do. So in order to get a patent, there are kind of 3 criteria. It has to be new, has to be useful, and it has to be non-obvious. And you can get patents for physical objects. You could also get patents for methods. In this case, it would be a method patent. The new usually is pretty easy to overcome just because any little thing that hasn't been done before, no matter how much you tweak it or how little you tweak it, is considered new. The useful part is also a pretty easy hurdle to overcome because almost anything has a use. This is to make a face more beautiful or something like that. Usually the biggest hurdle, if you get a patent rejection, is going to be the non-obvious part. So, sometimes your example is putting on makeup, but let's take an example of, a method of making also a new food item, like a new chicken dish. It's going to be obvious if you add like salt, pepper, and chicken that the final product is going to be something that tastes like chicken and salt and pepper. So there's nothing that's hard to overcome in that sense. So in the sense of doing like makeup and beauty, one of the hurdles might be, okay, well, it's obvious if you apply makeup in this way, it's going to give you this kind of look. But maybe this person has a new kind of blending technique that no one's ever done before. And or they're using different types of tools to give a certain kind of look. So the method will incorporate like using a brush that has these features and applying makeup, on this part of the face. So those are all things that potentially could be patentable. If you look up on patent databases, there are several of them. One that users might be able to look at pretty easily is called Free Patents Online. You could just type in method of applying makeup and you will see various patents that are there, method of applying makeup that goes through have the steps of A, B, and C. So if someone does something that, is A, B, and C, then they're infringing your patent. And if you're someone on TikTok and you have taken, someone else's, methods of applying makeup, and if that person is doing A, B, and C, then it's, patent infringement. And you'd have to get some type of, licensing deal, from the creator in order to, do it either yourself or to tell other people to do it.
Because I think that's something that digital content creators really struggle with when they are teaching their audience things that they've come up with, is that the little guys, the ones that are coming up with this, aren't getting the credit for it. Because once something goes viral, you kind of lose track of where this came from. And especially if a big brand then uses your method, the brand gets the credit for it. So oftentimes I get clients asking, like, can I patent this dance move that I did on TikTok? And, I don't think you can patent a dance move, but I think people are very curious about how they protect things that they put out there on the internet. Because
right. So
it feels very public domain when you do that.
Yeah. So in terms of, let's say, dance moves or choreography, potentially that is protectable through copyright. It's not my specialty, but from, what I understand is that you can register choreography through the Copyright Office. Okay. How long that would have to be in order for someone to get a registration for it? Like if I just, did 2 hand movements, that's probably not going to be copyrightable. I remember there are some issues with someone trying to copyright various yoga poses and doing them in a certain order. And there are lots of issues with that, whether that's copyrightable or not. So for the people who are just kind of doing a short snippet of a dance, that maybe just takes, 5 or 10 seconds, that might be on the more difficult end to get copyright protection for it. But if they're doing a longer thing, potentially that could be, copyright protection.
Yeah. So I think the dance moves was a bad example because that's a copyright thing. But I guess with the makeup processes, that could be theoretically be a patent. And if you wanted to protect it, you could, but that's always the question is, just because I can protect it, should I, you want people to talk about your methods and try your processes out online, but at the same time, you also want to protect it as well. It's weird. I don't really know what the answer to that is.
Yeah. And I think especially for people in that field, the cost of a patent is kind of prohibitive because, if you're spending $10,000 on a makeup technique, the question is, are you really going to ever recoup that from some potential infringers? The answer is maybe yes, maybe no. But for some people, it just might not be worth it. And, if you get knocked off, you get knocked off, but you were first to market because so you're first to market and, you make money that way, or you just get more followers, or for whatever reason, you can be successful without a patent. So I would caution someone if they came to me and said, I want to make a patent. I was like, we might be able to do it, but in the end, like, how valuable is it going to be? Are you going to hire attorneys to send cease and desist letters? And when you put that all together, maybe it's worth it, maybe it's not, but it's just something you always have to consider.
And I think perception is a big part of it too. Like if you are like this really famous makeup artist online and you have a patent to a method of applying, your makeup, and you're suddenly sending like cease and desist letters to like all these other content creators, I think it potentially would look bad to do something like that. It's just very weird because social media is a place where all the IP rules still apply, but people feel like it doesn't.
Right. Yeah,
it's
definitely.
Social media.
There are other intellectual property rights like trademarks and copyrights that we didn't go into. We just talked about patents because that's my experience, but there are going to be specific things about who owns artwork and designs and logos. And sometimes the answer is simple. And again, that's why sometimes it's not. That's why we have lawyers. And in future podcasts, we're going to have some of our other attorneys at Nolan Hyman that are going to talk about trademark and copyrights. Thank you for listening to the This podcast brought to you by Nolan Hyman, and we will see you next time.